Today's date is March 3rd, 2022, and we are going to hear a number of arguments via Zoom today. As you can see, the panel is Judge Carr, Judge Callahan, and myself. I'll be presiding and keep track of time. The first appeal we're going to hear is Postan versus Postan. That's case number 20CA0047M. Each party will have 15 minutes to present their arguments. Attorney Bancy, is that correct pronunciation?
It's close enough, Your Honor. Yes, Bunchy. It's a Hungarian name. Bunchy.
How do you pronounce it? Let me hear it.
Bunchy, like in bunchy grapes.
Okay,
Bunchy.
Bunchy. Attorney Bunchy, you can obviously reserve up to 5 minutes for rebuttal since you're the appellant. As you know, the oral arguments are recorded and posted on our YouTube channel, so we ask that you mute yourself when you're not presenting to the court.
Okay.
Don't think it applies, but if there are children or victims involved in the case, our rule is that we don't use those names. We refer to them as mother, father, child one, child two, or by initials. I know Judge Carr and Judge Callahan and I have read the briefs in this matter, and we are prepared to proceed. Do you know if you would like to reserve some time for rebuttal, Attorney Bunchy?
Yes, Your Honor. I'd like to reserve 5 minutes for rebuttal.
All right, I'll let you know as you get closer. I may have to interrupt you, but that way you'll know when you're at that point.
I don't think I'm going to be that long. If there's any background noise, I'm ensconced at the Lorain County Courthouse where I'm in the middle of a trial, but they broke for me and they set me up with the IT people. So
okay, wonderful.
I apologize for that.
No problem. We'll let you get started then. Go ahead.
Thank you. If may it please the panel, my name is Joseph Bunchy. I am counsel for the appellant, the father, in this appeal. I respectfully submit to the panel that this is a rather straightforward appeal. I did not want an oral argument, but now, you know, we are in the midst of it, so certainly I'm going to participate. I'm assuming that the court, as Your Honor mentioned, read the briefs and so forth. I'm not going to repeat a lot of it, or perhaps any of it, except the legal arguments. There are two assignments of error in this case. The first one is regarding Civil Rule 41B1, which relates to the dismissal of the complaint and counterclaim by the trial court. And the second is regarding the right of the due process rights of my client to a hearing regarding the matter of the motions that were filed. Briefly, as it impacts this appeal, the facts are that the parties reached an in-court settlement agreement, spent an entire day. The judge was not around. The original copy of the agreement was submitted to the judge. And that was the end of it. And then, of course, as attorneys, we knew that we have to submit a judgment entry and attach an agreement. And that was done in this case by Attorney Eubanks. She prepared one, a complete agreement, complete judgment entry, and it submitted it to me as counsel for the father. During COVID, I drove to the Medina County Courthouse, met my client at a picnic table outside with social distancing, and he executed the agreement that Attorney Eubanks prepared, signed the judgment entry with his approval signature. I did that, and I think I notarized it to, the agreement that needed notarization. I immediately walked it over to Medina Square to the offices of Attorney Eubanks and left it there. Now, this was something prepared by Attorney Eubanks. I get a call that she's not signing it, the very agreement that she prepared. So I then filed a motion to reduce the in-court settlement to judgment and asked for a hearing on it. There was opposition to that, and we heard nothing until we got a dismissal. There was absolutely no court order advising the parties that it's going to be dismissed if we don't submit a judgment entry and a separation agreement to the court. The appellate
I believe Attorney Eubanks in her brief mentioned that the court administrator provided notice that the case could be dismissed without a judgment entry. And she also, I think, referred to a Medina County local rule. Can you address those two arguments?
Yes. There was a administrator that kind of pinch hit it for the judge, and he may have said verbally that, you know, if we don't do this, then it may be dismissed, but that was the extent of it. There was no...
Counsel, I'm going to interrupt because I know you're answering Judge Teodosio's question, but I just want to make sure. None of this was on the record though, right?
That's correct. None of it. And
counsel, on that same issue, does that administrator serve in any capacity such as a magistrate or something would have been filed or anything? That goes to both of their questions.
No, he was, with all due respect to the court personnel, was just a clerk assisting the judge with the mechanics of the operation of the court to whatever extent the judge may have wanted that. He had no authority to adjudicate anything, either as a magistrate, as a mediator, or arbitrator, or certainly not as a judge. And we received no court order. And as I indicated in the brief, a court speaks through its journal to giving us notice. And Attorney Eubanks, you know, promptly prepared all the documents that we needed to present to the court, despite no notice. I immediately jumped on it, signed it, returned it to her. Her client didn't want to sign it.
And counsel, I am so sorry because I interrupted you and probably knocked you off course. Judge Teodosio actually asked you to address the local rule as well.
There is a local rule, but I don't think that local rule really rises to the level where there's a court order ordering a dismissal unless something is done. And that was not done, because not only that, if there is, then we are entitled to a hearing on that dismissal and defend against it. For instance, the defense that, look, Attorney Eubanks prepared the documents. The mother did not approve it. We couldn't submit it. I filed a motion with the court to reduce it to writing. All of this was pending before a dismissal. None of that was addressed by the court, but a dismissal of my complaint, I apologize, the father's complaint and the mother's complaint, both. After a year and a half of trial, and without even a hearing or a conference or something by the court or a magistrate addressing the issue. We went through a year and a half of trial, came to an agreement, and if allegedly there was something missing that the mother wanted, we didn't have the opportunity to address it and advise the court and have a hearing on it to correct and cure any defect in the case before dismissal. And that's what all of the case law from the 9th Appellate District state, as I have cited in the brief. It creates an incredible prejudice to the parties, and my client especially, after spending a year and a half in a contested divorce and coming to an agreement on every substantial issue of property. This did not involve children. There was no parental issues. It was strictly dollars and cents. And we did not get to address that issue at a hearing before the court, before a dismissal. I mean, I know I'm not arguing for the appellee, but I argued in my brief about the appellee because the same kind of prejudice occurred to the appellee on the counterclaim.
Why
And
wouldn't this all be moot since a subsequent complaint was filed and you're back before the court?
no, because it's not moot because my client is entitled to the due process in the existing case and have this court review the errors and send it back for a hearing. Okay, what is the dispute regarding? What hasn't been covered in that agreement that needed to be covered? And what is the position of the parties? And if nothing happens, then set it for trial. Now, the appellee is arguing it's moot because it's been dismissed, and now my client has to go through another 2 years of litigation on a whole bunch of new issues and factual patterns in the new divorce, which was closed out already by their agreement. It's not
Attorney
moot.
Bungie, I want to thank you for that answer, but I also have to let you know you're at that 10-minute mark. So you're
All right.
welcome to
Yep.
continue, but you'll be eating into your time.
All right.
Rebuttal time.
Well, Your Honor, I am basically, if it pleases the panel, I'm done, and I'll reserve my additional remarks in rebuttal.
All right, you'll have
Very
a full
much.
5 minutes for your rebuttal.
Thank you.
Attorney Eubanks?
Good morning. May it please the court, I am Renee Eubanks, and I represent the appellee, Amy Postan. I believe, first of all, this is we're going to have to go back down to the trial court. We're going to have to get divorced. We are arguing about whether we're going to get divorced in the first case or whether we're going to get divorced in the second case. I believe the appellant wants there to be an agreement. There is not an agreement. There were lots of details that went back and forth in negotiation. The settlement agreement does not include everything. There are 15 things that are missing. We did not divide tangible personal property. We could not come to an agreement on that. Ms. Postan is not willing to walk away from the marriage and not receive a couch, a dish, anything at all related to her tangible personal property. There are other
Counsel,
things. I'm sorry.
Counsel, I'm going to interrupt you because when I was reading your brief and as you start your argument, it occurred to me that it seems like what you're arguing is not that the matter is moot, but that you never had a settlement agreement to begin with. And if that's the argument, isn't that the reason why you have a hearing before the court and the court determines whether a settlement agreement exists?
I would agree with you, Your Honor, yes, but we can have the hearing either in the first case or in the second case. The second case has been filed. There are local rules that warn if the decrees are not and the documents are not presented to the court, we can be dismissed. We received many off-the-record warnings from the court administrator. We were not settled at the time we left the courthouse in February of 2020. Mr. Bungie and I discussed, we had a couple of details to work out yet, and we left the courthouse with the understanding that we were going to work out those details. And then COVID intervened.
Well, counsel, excuse me, but what authority does the court administrator have in terms of those warnings?
I don't know that he has authority. I believe that he was speaking for the judge when he warned us. I don't know that he has authority to make the warnings. I think Judge Baczynski, when he dismissed the case, was
Then Okay, I'm sorry, I should
permanently
not have
appointed-
interrupted you. Go
Was
ahead.
permanently appointed visiting judge who had the authority to make the dismissal.
Based upon what warnings on the record? I guess I would go to your argument in the brief and ask you to expound on it. It seems to me, unless I misread your argument, that your argument was that warnings aren't necessary.
I mean, the local rules indicate that they are not, and it is not, I think there's a distinction between when the case is dismissed with prejudice, which means your divorce case got dismissed, you have to stay married for the rest of your life, as opposed to an automobile accident or an employment suit or 1983 action, where this is your chance to bring it and there's a statute of limitations, and if you're dismissed, you can't come back. I think there's a distinction between those two kinds of cases and the warnings that are required.
Counsel, I know you're getting peppered with questions, so I apologize, but I'm also wondering with the local rules, you cite 801 and 803, but don't those specifically deal with just the decree and not necessarily a settlement agreement?
Well, that was, we did not present a decree, which is why the case was dismissed. Although I will acknowledge, we also did not have a final, the court did not conduct a final hearing. And in one or the other of the cases, the final hearing has to be conducted and the parties have to get divorced. When Mr. Banshee is talking about new fact patterns, there's been conduct by both parties, but I would assert from Ms. Postan's perspective, by the husband, that needs to be addressed. There was conduct that needs to be addressed between February of 2020 when we left the courthouse and June of 2020 when we got dismissed. I don't believe we can just pretend that everything's over in February. The subsequent case would indicate that that isn't where we are, and it's not equitable to do that. Ms. Postan would assert that the local rules and the domestic relations court was proper in dismissing the case, and we can proceed in the second case. And if there aren't further questions, I will stop there.
Anything further? Any questions, Judge Callahan?
No.
Or Judge Carr, anything further?
No, thank you.
All right, thank you, Attorney Eubanks. And Attorney Bungie, you have 5 minutes for your rebuttal. You're muted though, Attorney Bungie. There you go.
All right, thank you. I'm going to be brief in my responsive remarks. At first, I am just going to say to the panel that as an attorney who has been practicing for almost 50 years, I am rather disturbed by the arguments of appellant when the attorney for the mother herself prepared an extensive separation agreement and a judgment, which I attached to my motion. And my client accepted that and signed it. And then it was refused by her client. I find that very troubling, hearing her arguments here today, that there's so much of things were undone or whatever. If one looks at that agreement, every substantial financial issue was addressed. We addressed the marital, the home that they lived in during the marriage, support, spousal support, property, pension accounts, and so forth.
Attorney Bungie, I'm going to suggest to you or ask you, aren't you arguing the merits of the settlement agreement just like Attorney Eubanks? I was questioning her. You're
No.
saying there was one, she's saying there wasn't one. Well, isn't
No.
that the whole issue? We're not there necessarily.
Okay, there was an agreement. And the agreement was confirmed by the attorney for the mother when she drafted the formal typewritten agreement and the judgment entry and submitted it to me for my client's approval and signature, which happened. I am, of course, aware that in these situations, especially in divorce cases, clients often have buyer's remorse and don't want to sign something that or they don't want to go through with something that they signed. But that is why there are remedies of going back to the court to ask the court to adopt the agreement as orders of the court. That is the final order with respect to the financial aspects of it. And the plaintiff is entitled to a hearing on it, a full hearing, and he is entitled to notice from the judge, who's the only one that's going to speak for the court, or can really legally, to instruct the parties what is going to happen to them. And that has not been done. And that's why I am seeking that it be remanded to the trial court for a hearing. And with that, I respectfully close my remarks unless the panel has any questions of me.
Would you agree that the proposed separation agreement was not all encompassing? In other words, there were other issues that still needed to be worked out?
No, everything was agreed to.
Tangible personal property, it sounds like may have still been at issue, or?
That, the actual facts regarding that, the parties already divided the personal property prior to the agreement, and there was no, mention of that in the agreement to, with respect to personal property.
Okay. Any further questions from Judge Callahan or Judge Carr?
No, thank you.
All right, you've got about 40 seconds left. Do you have anything further, Attorney Banshee?
No, thank you. The panel was most patient, and I thank you. And I'm not going to beat a dead horse.
All right. Well, we appreciate that, and we appreciate you both appearing here today by Zoom and the arguments that you presented today. We're going to take the matter under advisement. We'll issue a decision in due course. As you both probably know, the clerk of courts will mail you a copy of the decision on the day it's released, and you can also locate the decisions on the Supreme Courts of Ohio's website where they're posted. So again, on behalf of Judge Carr and Judge Callahan, we appreciate your patience this morning and getting the late start and the arguments that you've made to us. So you all have a good day.